Let me keep working on this one. This is what I'm thinking about.
Okay,
You have a reasonable doubt.
He's looking at instruction because their concern now is that his...
Well, it's really saying is, so you have a reasonable doubt as to elements 1A, B, or C, right? Any one of those three. Or you have a reasonable doubt as to A, B, or A or B, or you have a reasonable doubt as to element 3. Makes it a little longer, but that's what you're really saying. Is that correct, counsel? Do it again. A, B, or C, right?
Right.
Or you have a reasonable doubt as to 2A or B. Or you have a reasonable doubt as to element 3. Then it will be your duty to return a verdict of not guilty. That gets real simplistic, but I think it's clear. Would you agree? You may. Go ahead. Did you understand what I said, Mr. Robinson?
I understand what you're saying, Your Honor.
Does that make it clear? 1A, B, or C. Now, if it was just one, you'd say 1A, B, C, or D, which would be the state, any of those four. But element 3 is the same. So it's 1A, B, or C, or you have a reasonable doubt as to, wait a minute, that's not.
The problem,
The problem with that is they only,
the problem
I understand what you're saying. The problem with that is they could have a reasonable doubt as to A or B on either one, but as long as they find a reason,
that's our problem.
That's a
what,
problem.
That's what I wrestled with.
It is. All right, hold on.
David.
Well, I'll continue to take input. All right. Mr. Arbenbecker, I'll let you think about it, continuing, okay? Let's go on the record. You with us?
Yes, Your Honor.
We're back on the record, State of Washington versus Martin David Pietz. At my request, counsel worked on the to convict instruction overnight. I received a modified version of the to convict, which I have now numbered as 10. The instruction numbers changed a bit since yesterday because I received a supplemental instruction from the defense, which deals with alleged out-of-court statements of the defendant, and since that's a standard instruction and the state doesn't, the state agrees with it, I've put that into the stack, which is then change the numbering of instructions after 6. So the one we're working with now in the new pack of jury instructions is instruction number 10, which is the to convict instruction. And I've heard from Mr. Offenbecker that he still has concerns about the really the grammar of the instruction and how it's to be interpreted and whether it's still ambiguous.
That's correct, Your Honor, and I want to put all of my objections to this instruction on the record. First of all, I want the court to know that we're objecting to the method of charging in this case, which is the conjunctive in the amended information.
Can we set that aside for just a second? Because that's the case that I haven't even looked at yet.
And I haven't looked at it yet, Your Honor.
Let's deal with the language of the instruction first, because that's what we were wrestling with a minute ago.
Okay, and let me take all of my objections so the court can understand all of my concerns. I want to start, though, with the second page, which I think is the most important one. The proposed instruction says, on the other hand, if after weighing all of the evidence you have a reasonable doubt as to elements 1A, B, and C, and 2A and B, then it will be your duty to return a verdict of not guilty. The way this instruction is phrased, it makes it sound like in order to find Mr. Pietz not guilty, you have to have a reasonable doubt as to all of the elements. Now, that's not true if they have a reasonable doubt as to one of the elements under one of the particular alternative means.
You know, the problem, it seems to me, is who you refers to. Because you understand that they don't have to be unanimous. So you can be each individual juror, or you can be the jury as a whole. If it's each individual juror, then they could have a reasonable doubt as to A or B, or as to 1A or B, or as to 2A or B. And in fact, as long as they agreed on the other one, they didn't have a reasonable doubt, it would be to convict, or they could vote that way. But the jury doesn't have to be unanimous on it. That's the problem.
Right, I understand, but I spent, at the court's request, I spent several hours trying to draft an instruction that I think accurately reflected the law as well as the burdens required by the Constitution, and I frankly can't do it. The way it's phrased now, it says as to elements, and then it lists them out, and it has and in between each of them, and I think it could lead the jury to find that they're required to find a reasonable doubt as to all of these elements collectively.
Would your preference be just leave that out?
My preference would be that
leave it out and let you guys explain it. Since you can't explain it on paper, you can explain it in closing?
Your Honor, we're asking that the court be required to select which means of murder that the state
be required to decide which way I charge?
That the state be required to elect which alternative means of murder in the second degree they're pursuing, because I cannot figure out a way to write this instruction that appropriately reflects the law.
That's not the basis for overturning the appellate court saying it's okay to do it this way. Maybe they haven't given us a good instruction on how to do it. But let me take a look at the case that's just been presented to me, which is State versus Dixon.
That's the conjunctive charging case.
I understand that.
Does Your Honor want to hear my other issues with this instruction before you read that?
Okay.
Okay. If we go back to the first page, the bottom paragraph, it says elements 1A, B, and C, and 2A and B are alternatives, and only one need be proved. It's not clear the way that these subsections are inserted in here which are the alternatives. Is it all of 1 and all of 2, or is it 1A, B, and C, 2A and B? Are those all separate alternatives and only one of those need to be proved? Additionally, it's not...
Did you say there are a lot of ands in there?
Yes. Additionally, it's not clear why they need to be proved. There's no clause in there that says, in order to find the defendant guilty, one of these alternatives need to be proved.
But you don't have any different language to give me? You're saying because none of us are grammar experts that we have to give up on this and just submit it to the jury, the Court of Appeals, to write the right instruction, and then if we get it wrong, they'll just reverse?
Well, Your Honor, there is a pattern instruction, 4.23, which uses some language, this is for alternative means. To return a verdict of guilty, the jury need not be unanimous as to which alternatives, and then it includes a couple of alternatives, has been proved beyond a reasonable doubt, as long as each juror finds that at least one alternative has been proved beyond a reasonable doubt. But that language is not in here.
But you haven't submitted it either.
Because I cannot figure out how to write the last sentence in a way that makes sense. The next sentence, I want to make clear our objection to that. You must unanimously agree that either 1A, B, and C, or 2A and B has been proved. It's a statement that they must unanimously agree that one of these has been proved. There's not.
You mean we're directing them to find it?
That's one way it could be interpreted. There's not a clause that says in order to find the defendant guilty.
Well, then we can put that in. That's easy enough. But you haven't submitted one.
And if I was going to submit one, that's what I would include. But I still cannot get over figuring out how to instruct the jury on reasonable doubt as to elements.
Let's back up a second. Let me read this case, okay? This is the one that Kate State just submitted. I assume this deals with instructing or charging in the, they call it the disjunctive? The conjunctive?
Conjunctive means and, or the conjunction is and that case basically says if you have alternative means, you
All
can
right,
charge
we'll
with
call it the
and.
conjunctive then.
Correct.
This is the last case, 1971? You want to help me out as to what page I should be looking at? Acts or conduct described in the penal statute in the disjunctive. Or alternative may be pleaded in the conjunctive. All right. All right, I read that. That's heading 4, 5, and 6. Where in here does it say that the way you charge it with is with and rather than or? Well, where does it say that's the way you do it? Well, where's the case that deals with the language you put into the information? You said you had that too, and they've approved that language.
That is the case, that you can charge in the conjunctive with
I
and.
understand you can charge in the disjunctive or the conjunctive,
Correct.
but if you charge in the conjunctive, where's the case as to the appropriate language that you use to charge?
I believe.
This is a grammar lesson.
I believe that conjunctive equals and so
So you're saying you don't have that case
I don't think there
that
is.
specifically addresses that?
I mean, unless you, the dictionary, I guess, would say it. I don't know that there's a case that
All
says-
I'm asking is, do you have a case where you've charged it with this language, where the Court of Appeals has said that's just fine, that is language that charges in the conjunctive? We're dealing with wordsmithing here, and I'm trying to get the appropriate language as approved by our appellate courts for charging in the conjunctive.
Well, Your Honor, I did not look for a case that said that, because to me, I mean, the way that I read this, and from my research, this was the seminal case that says alternative means can be charged in the conjunctive. Conjunctive means and that is why we use the word and. I did not look for a case that says conjunctive means and. but that's the
No,
dictionary
I'm
definition.
simply looking for the case that says the proper charging language. I'm not asking somebody to go to Webster's and define conjunctive or disjunctive for me. I'm simply
that's the-
saying, I had understood you say that you charge it this way, and it has been approved by the Court of Appeals for
Right.
charging in the conjunctive.
It says it may be pleaded in the conjunctive. That's referencing charging.
And what's the appropriate language for pleading in the conjunctive? That's what I'm asking. Have they not addressed that, or you just assume the dictionary says the appropriate word would be and?
I did not look for a case that said conjunctive equals and, because I just didn't look for it.
All right. Anything else?
No, Your Honor. We're asking that the state be required to select one of the alternative means. I have two convicts for each of the alternative means that can be used. We think that's a simpler way to do it. We don't think that the proposed instruction reflects the law.
Let me tell you, it is a simpler way to do it, but I'm not sure they're required to do it that way.
And Your Honor, I'm happy to type, and I have in fact typed in the language on the first page in order to find the defendant guilty,
All right,
comma.
are you on instruction 10 now?
Yes, I'm happy to type that in. I've done it on here, and I can email it to your bailiff if we want to
What
add
are you
that.
typing in?
The concern that Mr. Offenbecker had on
Just a
the,
second. I'm trying to find it.
it's the
Hold on.
page, the first page of instruction 10.
All right.
The first page of instruction 10.
Correct.
At the beginning of the second to last sentence, we can write in or type in order to find the defendant guilty, comma, you must unanimously agree. Mr. Offenbecker expressed concern that somehow we were commanding them to find him guilty, so that would take care of that
That
concern.
takes care of what I just said a minute to.
Yeah, so would you like me to, I just
We'll
revised it, I can
put
email
that
it to your
in. That
bailiff.
doesn't take care of the potential ambiguity on the second page.
I understand.
Let's just make it work. No, we can't.
You want to consult with your appellate bureau?
Well, we have, and I don't know, Mr. McDonald's here, and I did
They
ask
haven't done any
him,
better than this?
The concern with changing that language is that it makes the jury think that they basically, if they don't find one A, B, and C, even if they find two A and B, they somehow can't convict, because it's basically saying, if you find a reasonable doubt to any of these, you can't convict, which is not correct. They can find a reasonable doubt as to the intentional
All
murder
right, I'm going to,
and still convict
let
on
me
the felony.
suggest a defense. I'm going to leave it this way. If you want to submit what you think to be a clarification of the English language to deal with this, you may. I will listen very carefully during closing arguments to make sure that both of you argue the case consistent with what we all understand the law to be. Jury instructions are appropriate if they allow you to argue your theory of the case and do not misstate the law. And the fact that it could conceivably be construed in a way that would misstate the law doesn't necessarily indicate that it's an improper instruction. If the problem is the fact that the English language is subjected to ambiguity and no one here can phrase it so it's unambiguous. So I will continue to look to the defense to phrase it in a way you think is unambiguous, given the fact that everybody agrees what the law is.
We stand by our exception, Your Honor.
And would it be your preference just to leave it in or take that sentence out entirely?
Your Honor, I'm going to stand on our prior arguments.
Would it be your preference to take it out entirely or leave it in? I'm giving you the choice. You're saying you're not going to make that choice? You can say,
Your Honor, I think-
you can say, Judge, I'm not going to answer, I'm not making that choice, or you can say, Judge, I would prefer to leave it in, or Judge, I prefer to leave it out. There are three options. That covers the universe.
Your Honor, I don't think either phrasing is acceptable. We're standing by our prior exceptions in the arguments that I made.
So that tells me you're not going to answer my question.
I think the jury needs to be instructed that if one of the elements of each alternative is not found, then they have to return a verdict of not guilty. I cannot figure out an appropriate way to phrase it. We've stated our position as to what we think the problem is. Given the way that it's been charged, I don't have another suggestion.
I'll leave it the way it is then.
Your Honor, I am emailing to your bailiff.
All right, I've got it. The
You've got it?
instruction
Okay.
in order to find the defendant guilty will be inserted when I read it to the jury.
Thank you, Your Honor. The only-
Anything else on the court's instructions?
Not on the instructions, Your Honor.
Anything else? You said not on the instructions. You
No.
intend to suggest there is something on another issue.
Just a favor, Your Honor. I came up early because I want to test our PowerPoint for closing. I would like just a couple minutes to do that to make sure the audio is working so we don't have a problem during closing. If we could do that before the jury comes out. The other thing I wanted to let the court know, we did bring up the cleaned up desktop. We can address that now or we can address that later. I don't know if either counsel wants to talk about
Where's
that.
the cleaned up desktop?
It's right here, Your Honor. I went through it last night. There is no, you cannot access internet. There's no files on it.
Where is it?
It's right here. So I'm happy to let whoever wants to look at it.
So, what am I supposed to go get somebody up in IT for the court
I think that it's,
to go through this thing and instruct me into what you can do with a computer?
my suggestion would be this, that we all get in front of it and I can show everybody what's on it. You cannot access internet. When you hit the little E, it blocks you out. There are no files under any of the hard drive files. There are a few, I'm not sure what the right word is, players to play various media devices that you can't do anything with unless you have a CDN that plays those devices. So there is simply nothing they can do with it other than stick in a piece of evidence in this case and pull it up.
All the evidence we're submitting to them, it's all played by the same device, or do you have to
the
figure
way-
out going through the computer which device you need to play it?
No, it can, all they have to do is pull it up. We purposely, when we set them up for trial so that we could play them in court, have it set up so that you literally just open it once it's in there. So there's not devices they have to worry about. They put the CD in, they pull it up, and they will play it. So there aren't issues in that regard. Obviously, as with anything else, if the jury has a question, they will ask a question, but there's no specific device. They don't have to access anything to play it other than to put it in.
All right, would you pass the computer up here?
It's on a cart, so we can roll it over here.
It's on a cart?
Yeah,
Maybe
it's
you're going to roll it into the jury room on that cart?
well, it's a desktop, so yes, that's what we will have to do. So where would the court like it?
Still plugged in? Have you gone through this? No.
I had it up here early, so I could do that. So.
Log it in. So they have to log in as TLN245605/mobile.
I'll show you when the username comes up. They'll type in mobile, and then they type in that password. Are we on the record, Your Honor? Just
They're still on the record.
sorry, I'm not speaking
Remember
loud
that
enough.
old open court thing?
Everything said about logging in. They will have to log in using the username mobile, and then the password listed here is HOBNOB65.
What the appellate court is listing, is this the thing that you have to do on the open court under Bone Club?
Okay, so it gives the instructions, Control Alt Delete. They will hit. And then you okay. Make sure you keep your voice up, please. I'm sorry. It says Control Alt Delete, and then they hit OK, and then this is where they have to type in the password that's on here. And then you can see what's on the desktop. If you go into Word, there are no files that I will show the court counsel. I will ask Mr. Oppenbecker to check if he wishes. Go ahead.
You know what all the shortcuts are? Shortcuts.
I can't hear anything you're saying, guys. Sorry.
I have opened up a folder on the computer
It says appellate.
that says appellate. I opened that up. There's maybe 50 Word documents in it.
Oh, I think only 47.
I think Steve's not going to.
All right, forget it. We're not using it. We've gone far enough. I'm not going to spend any more of the court's time trying to clean up a computer. What's next? The jury will be told by the bailiff if they want to review any of these computer files, they will come back in court, and it will be done in open court. Anything else?
Just, I would ask for a couple minutes to make sure the PowerPoint is working, Your Honor, if we could.
Your Honor, I would ask that the state print out a copy of the PowerPoint so that I have it and the court has it in case there's anything objectionable in it. I've had cases before where I believe there have...
Can you do that?
We have it printed out, it's downstairs, I'll have the paralegal retrieve it.
Thank you.
Thank you, Your Honor.
There should be 2 copies.
Huh? All right, we need to have everybody seated and not blocking the jury room. I don't know if this is, we don't want the jury room blocked for people. There are more seats up here, and I'm not going to prevent anybody from coming in. Does everybody hear that? I'm not preventing anyone from coming into my courtroom.
Your Honor, is the court going to have your bailiff make copies of the jury instructions?
Yes.
Thank you, Your Honor.
Terry?
Need to see a final version before she makes copies.
Your Honor, should we take a look at a final version just to make sure it's consistent with your rulings before copies are made?
Well, the final version has "in order to find the defendant guilty" here. So that hadn't been typed in, but you can take a look at it.
Your Honor, I'm not seeing the instruction. Oh, I take that back.
Which one? The one you just submitted? It's number 6, isn't it? All right, you, Counsel, Mr. Oppenbecker, you look forward, they conform to what we decided?
They appear to reflect the court's ruling, yes.
All right, and the state, you need to copy these right now?
I'll look at it, Your Honor.
All right, you're not going to shoot that on multiple frames per second, are you? Okay. I assume that has a capacity. Is that the Canon 070?
And Your Honor, will your bailiff make copies for counsel with the
As soon
following?
as she can get to it.
Thank you, Your Honor.
Terry,
Yes, sir.
can you photocopy these? And counsel, I'm not have her worry about those 3 extra words for now. You'll get them with the interlineation. I'll read them that way, and we'll clean it up before they go back to the jury.
It'll be typed in.
It'll be typed in. Yes, I clean it up, meaning she'll type those words in. They won't be handwritten.
So I take it you won't have the jury looking at them as,
Correct.
would the court tell the jury, though, that they will get copies? Because I'm always concerned when jurors start to try to write the instructions in their book. In other words,
Normally, I send back 1 copy unless they request multiple copies.
well, at least tell them that they'll get a copy back
Oh,
there.
I tell them that.
So they don't have to.
No, counsel, I tell them you will receive a copy of these jury instructions back in the jury room. You need not write down any specific instructions unless you think you need to, but you'll receive them verbatim back there.
Thank
I
you.
do not send 12 different copies back there unless they later request additional copies. And
Okay.
occasionally they do.
Yes, Your Honor. Your Honor, since we're waiting for that, can I be excused for a minute?
Go ahead.
Thank you.
I'll be right back.
should say there's some sections toward the back that are not going to be. Starting with this one at the back, Cooper. And then nothing after that we're going to use. Including that one. It's before that. Right, so starting there.
Hold on. Including this one.
Correct.
So I should stay with that.
Correct. So it's like the last step.
Mr. Allen, you now have a copy of their PowerPoint presentation of closing argument in front of you.
Yes, Your Honor, reviewing.
Only one of them. Number 6. No, not 6. Which one was it? One of them's got a lineation on it to convict. Right here. Terry. Number 10. You know, just make a copy of what I did there.
Your Honor, there's one more thing we can put on the record while council's reviewing that. We talked about this yesterday, but we just wanted to indicate the two substitutions on the evidence that we indicated yesterday. Glossy photos were substituted for the color copies in Exhibit 121, which was the Dr. Mazren photos. And in Exhibit 33, which was the DVD of the video of the body scene, we only offered the first 8 minutes. The CD that we played in court had the entirety of it on it, so we edited it, and now it's just what was shown in court that is in evidence. So I just wanted to indicate to everybody that's been done, and we had mentioned that to council previously. So if anybody needs to review those, they're welcome to do so before they go back to the jury.
Carla, can I move
Your Honor, I
slides?
apologize.
Can I move
I
slides?
actually was not listening.
Listening to what council was saying, we were reviewing the PowerPoint.
You want the court reporter to read back so you know exactly what she told you?
No, I'm
happy to repeat it.
All right.
We substituted in Exhibit 121 the Dr. Mazren photos. We substituted glossy photos for the color copies. And in Exhibit 33, which was the DVD video of the body recovery scene, we substituted because we only showed the first 8 minutes, and that's all we intended to offer. And the CD that was in evidence was the entirety of the body video. So we substituted what was offered and played in court. So council's welcome to review those before they go back to the jury for deliberations if they wish to check on that.
I want to move these two out. Which one?
The DVDs will go back to the jury room. My bailiff will inform the jury that if they wish to listen or to watch any of it, they must send a note to her, and they'll be brought back into court for that purpose. Mr. Allen, have you gotten through that?
Say again?
The PowerPoint?
Yes, we have.
Oh, okay, I was waiting for any
Oh.
comments you might have.
We just got through, oh, I'm sorry. Just so I'm clear, does the state plan to play those portions of the tape-recorded admission by the defendant that are set out in the PowerPoint?
Yes.
Okay. I've read them, Your Honor. I don't see anything patently objectionable.
All right. You mean the defendant's statements?
Right, Your Honor, they were admitted.
You use the term admissions.
Well, they came in
Statements. They
as
come in
a...
as statements by a party opponent.
Stand corrected, Your Honor. Thank you.
All right, are we ready for the jury?
Eric, we checked one thing, there may be one errant tape that shouldn't be in there.
Is that how it- All right. Now, did you have to retype that, or did you just inserted it?
It's the wrong click.
You took theirs, it was already on disk, and just inserted those, so I don't have to reread the rest of it.
Correct. All
Okay.
I did is,
Inserted in order to find.
in order to find on page one of number,
All right. Would you give them each one of those a copy of it, then they'll have the finals. Wait a minute, hold on. Is that the one I just? Just a second.
So this is substituted?
Hold on. Just a second. Terry? I'm looking at this again. What did I just?
Is that not right?
You put it in the wrong place.
Oh.
You put it here instead of there.
sorry.
You have to redo that.
So do we not substitute?
Do not substitute that. In order to find the defendant guilty was inserted at the wrong spot.
I would submit actually that we could have that clause in both of those sentences.
Hang on, sorry, what's that?
Instruction number 10.
Do you have any objection to both?
I can't.
What?
Your Honor, I'm not clear where we're looking.
All right. We're looking at instruction 10, first page, 3 lines from the bottom. Previously started, you must unanimously agree that either A, 1A, B, and C, or 2A, B, and C have been approved at the request of, or with the concurrence of the state. At the beginning of this, I inserted in order to find the defendant guilty. The revised one you have there, in fact, has that clause inserted in front of the next sentence. The defense is now asking that the clause be inserted in front of both sentences.
Your Honor, I'll retract that.
All right. In that case, Jerry is now putting it in front of the correct sentence. All right. Give me a copy of that. All right, counsel, with that, is everyone ready to bring the jury in? Is anyone listening? Counsel, are you ready for the jury?
Your Honor, we're almost ready for the jury, we just don't
All
want to...
right, well, I just appreciate a response when I ask the question.
I'm sorry, well,
Your Honor, the defense is ready.
we're ready, Your Honor.
All right, bring the jury in.
Could I use your stapler? Okay. Yeah, thank you.
This could be a first.
Please rise for the jury.
Please be seated. Members of the jury, I will now read to you the court's instructions as it is applicable to this case. You will receive a set of these original instructions back in the jury room, so it's not necessary that you take any notes on these instructions unless you're inclined to do so. I certainly wouldn't prohibit you from writing down notes during these instructions. It is your duty to decide the facts in this case based on the evidence presented to you during the trial. It is also your duty to accept the law from my instructions, regardless of what you personally believe the law is or what you personally think it should be. You must apply the law from my instructions to the facts that you decide have been proved, and in this way decide the case. Keep in mind that a charge is only an accusation. The filing of a charge is not evidence that the charge is true. Your decisions as jurors must be based solely upon the evidence presented during these proceedings. The evidence you are to consider during your deliberations consists of the testimony you've heard from the witnesses, stipulations, and exhibits that I have admitted during the trial. If evidence was not admitted or was stricken from the record, you are not to consider it in reaching your verdict. Exhibits may have been marked by the court clerk and given a number, but they do not go with you to the jury room during your deliberations unless they have been admitted into evidence. The exhibits that have been admitted will be available for you in the jury room, and you will see that a number of exhibits were not admitted, so do not expect to find all exhibits from number 1 through the end of the exhibits. There will be missing exhibits. One of my duties has been a rule on the admissibility of evidence. Do not be concerned during your deliberations about the rulings for my rulings on the evidence. If I've ruled that evidence is inadmissible, or I've asked you to disregard any evidence, you must not discuss that evidence during your deliberations or consider it in reaching a verdict. Do not speculate whether the evidence would have favored one party or the other. In order to decide whether any proposition has been proved, you must consider all of the evidence that I've admitted that relates to that proposition. Each party is entitled to the benefit of the evidence, whether produced by that party or not. You are the sole judges of the credibility of each witness. You are also the sole judges of the value or weight to be given to the testimony of each witness. In considering a witness's testimony, you may consider, among other things, the opportunity of the witness to observe or know the things that he or she testifies about, the ability of the witness to observe accurately, the quality of a witness's memory while testifying, the manner of the witness while testifying, any personal interest the witness may have in the outcome of the issues, any bias or prejudice the witness may have shown, and any other factors that affect your evaluation or belief of a witness or your evaluation of his or her testimony. The lawyer's remarks, statements, and arguments are intended to help you understand the evidence and apply the law. It is important, however, to remember that the lawyer's statements are not evidence. The evidence is the testimony and the exhibits. The law is contained in my instructions to you. You must disregard any remark, statement, or argument that is not supported by the evidence, so the law is contained in these instructions. You've heard objections made by the lawyers during trial. Each lawyer has the right to object to questions asked by another lawyer and may have a duty to do so. These objections should not influence you. Do not make any assumptions or draw any conclusions based upon the lawyer's objections. Our state constitution prohibits a trial judge from making a comment on the evidence. It would be improper for me to express by words or conduct my personal opinion about the value of testimony or other evidence. I've not intentionally done this. If it appears to you that during the course of the trial or the giving of these instructions I've made an apparent comment, you are to disregard that comment entirely. You have nothing whatsoever to do with any punishment that may be imposed in case of violation of the law. You may not consider the fact that punishment may follow conviction, except insofar as it may tend to make you careful. The order of these instructions has no significance as to the relative importance. They are all important. In closing arguments, the lawyers may properly discuss specific instructions. During your deliberations, you must consider the instructions as a whole. As jurors, you're officers of the court. You must not let your emotions overcome your rational thought process. You must reach your decision based on the facts proved to you and the law given to you, not on sympathy, prejudice, or personal preference. To assure that all parties receive a fair trial, you must act impartially with an earnest desire to reach a proper verdict. As jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a unanimous verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During your deliberations, you should not hesitate to re-examine your own views and change your opinion based on further review of the evidence and these instructions. You should not, however, surrender your honest belief about the value or significance of evidence solely because of the opinions of your fellow jurors, nor should you change your mind just for the purpose of reaching a verdict. The defendant has entered a plea of not guilty. That plea puts in issue every element of the crime charged. The state is the plaintiff and has the burden of proving each element of the charge of the crime beyond a reasonable doubt. The defendant has no burden of proving that a reasonable doubt exists as to these elements. A defendant is presumed innocent. This presumption continues throughout the entire trial, unless during your deliberations you find it's been overcome by evidence beyond a reasonable doubt. A reasonable doubt is one for which a reason exists and may arise from the evidence or lack of evidence. It is such a doubt as would exist in the mind of a reasonable person. after fully, fairly, and carefully considering all of the evidence or lack of evidence. If, after such consideration, you have an abiding belief in the truth of the charge, you are satisfied beyond a reasonable doubt. The evidence that's been presented to you may be either direct or circumstantial. The term, direct evidence, refers to evidence that's given by a witness who has directly perceived something at issue in the case. The term, circumstantial evidence, refers to evidence from which, based on your common sense and experience, you may reasonably infer something that is at issue in the case. The law does not distinguish between the weight to be given to direct or circumstantial evidence. One is not necessarily more or less valuable than the other. The defendant is not required to testify. You may not use the fact the defendant has not testified to infer guilt or to prejudice him in any way. You may give such weight and credibility to any alleged out-of-court statements of the defendant as you see fit, taking into consideration the surrounding circumstances. A witness who has special training, education, or experience may be allowed to express an opinion in addition to giving testimony as to facts. You are not, however, required to accept his or her opinion. To determine the credibility and weight to be given to this type of evidence, you may consider, among other things, the education, training, experience, knowledge, and ability of the witness. You may also consider the reasons given for the opinion and the sources of his or her information, as well as considering the factors already given you for evaluating the testimony of any other witness. A person commits the crime of murder in the second degree when he or she commits or attempts to commit assault in the second degree, and in the course of and in furtherance of such crime or in immediate flight from such crime, he or she causes the death of a person other than one of the participants. A person commits the crime of murder in the second degree when with intent to cause the death of another person, but without premeditation, he or she causes the death of such person or a third person. This is called the to convict instruction. I listen carefully because when it gets toward the end, it gets somewhat complicated, and you're going to have this back in the jury room to review. To convict the defendant of the crime of murder in the second degree, each of the following elements of the crime must be proved beyond a reasonable doubt. Counsel, you know that somehow the numbering on that got off. You see it? I've changed it on there, and it will be reordered, the jury instructions, with all the different drafts. 1, that on or about January 27, 2006 through January 28, 2006, the defendant, A, was committing or attempting to commit the crime of assault in the second degree. B, caused the death of Nicole Pietz in the course of and in furtherance of such crime or an immediate flight from such crime. And C, that Nicole Pietz was not a participant in the crime. Or that on or about January 20, 2006 through January 27, 2006 through January 28, 2006, the defendant, C, acted with intent to cause the death of Nicole Pietz, and that Nicole Pietz died as a result of the defendant's acts, and that any of his acts occurred in the state of Washington. If you find from the evidence that elements 1A, B, and C, or 2A and B, and elements 3 have been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. Elements A, B, and C, and 2A and B are alternatives, and only one needs to be proved. In order to find the defendant guilty, you must unanimously agree that either 1A, B, and C, or 2A and B have been proved. You are not required to unanimously agree which of either 1A and B and C or 2A and B have been proved. On the other hand, If after weighing all of the evidence you have a reasonable doubt as to elements 1A, B, and C, and 2 and B, A and B, and elements 3, it will be your duty to return a verdict of not guilty. Now, counsel during closing arguments can explain to you what they think this means in terms of the evidence. A person commits the crime of assault in the second degree when he or she intentionally assaults another by strangulation. A person acts with intent or intentionally when acting with the objective or purpose to accomplish a result that constitutes a crime. An assault is an intentional touching or striking of another person that is harmful or offensive. Strangulation means to compress a person's neck, thereby obstructing the person's blood flow or ability to breathe, or doing so with the intent to obstruct the person's blood flow or ability to breathe. A participant in a crime is a person who is involved in committing that crime either as a principal or an accomplice. A victim of crime is not a participant in that crime. When you begin deliberating, your first duty is to select a presiding juror. The presiding juror's duty is to see that you discuss the issues in this case in an orderly and reasonable manner, that you discuss each issue submitted for your decision fully and fairly, and that each of you has a chance to be heard in each question before you. During your deliberations, you may discuss any notes you've taken during trial if you wish. You've been allowed to take notes to assist you in remembering clearly, not to substitute for your memory or the memories or notes of other jurors. Do not assume that your notes are more or less accurate than your memory. You will need to rely on your notes and memory as to the testimony presented in this case. Testimony will rarely, if ever, be repeated for you during your deliberations. If after carefully reviewing the evidence and instructions you feel a need to ask the court a legal or procedural question that you have been unable to answer, write the question out simply and clearly. In your question, do not state how the jury has voted. The presiding juror should sign and date the question, give it to the bailiff. I will confer with the lawyers to see what, if any, answer can be given. You will be given the exhibits admitted in evidence, these instructions, and a verdict form for returning your verdict. Some exhibits and visual aids have been used in court but will not go with you to the jury room. The exhibits that have been admitted will be available for you in the jury room. You must fill in the blank provided in the verdict form the word not guilty or the word guilty according to the decision you reach. Because this is a criminal case, each of you must agree for you to return a verdict. When all of you have so agreed, fill in the verdict forms to express your decision. The presiding juror will sign the form and notify the bailiff. The bailiff will bring you into court to declare your verdict. Attached to these instructions is a verdict form. I will not read it to you. Counsel may read it to you if they wish during the course of their closing arguments and may suggest to you, based on all of the evidence and the court's instructions, how the jury should fill out that verdict form. With that, if you'll give your attention to counsel, your closing arguments.
Thank you, Your Honor.
Would you tell Siri somehow let's do this?
Good morning. We know everything we need to know. We know Nicole Pietz now. We know her husband, the defendant. We know how she died. We know how he lied. And we know a lot more. We know the big picture and how the big things may have been done right, but the little things are what do him in this case. Because they pile up to create a mountain of evidence, enough pieces of a puzzle so that you can tell what the picture is depicting, even if there are some pieces missing. And it gives us a picture of what happened. The little things speak loudly about him and about her. You know something about her, that she had a pill problem in the past, 8 years in the past before she died. Not at the time she died. We know that because of her blood tests. You know she doesn't wear her retainer out of the house because it makes her lisp. And you know to a degree that she was something of a blind apologist for her husband. And we know something about him. We know that he's an extraordinarily cold and callous man, the kind of man who does something just like this. So lacking in empathy, he can't even fake the caring that was necessary to show himself as a husband who was upset about his wife missing. Defense counsel told you what happened to Nicole Pietz is a mystery. That implies something that's interesting, entertaining, like a book or a TV show, mystery. This is no mystery. There's nothing fictional about what happened to her. This is not some old movie on a video that gets discarded after the mystery's been watched, like he discarded her in the woods in that trash heap in Burien. This is permanent, like a gravestone. This is not a novel, it's not a mini-series. This is a human life we are talking about. And sometimes with all the stuff that flies around a courtroom and a trial, it's really easy to forget that. This is a crime. It's called murder in the second degree. And there's no mystery here. The defendant committed it. You know, that lack of caring, that inability to appear caring, is sort of where he went very wrong. And that is a very big thing in a case about a lot of little things. So I want to show you what we call the elements of the crime, and that will be on instruction 10, the one that did sound quite confusing at the end. Hopefully it will make sense once we've had a chance to talk about it, and I think it will give you a little bit of an overview of where we're headed. Jury instruction 10 is what we call the to convict instruction, because it says to convict the defendant of the crime of murder in the second degree. You must find the following. And in this case, it's broken down into two options, basically. The first is that he was committing or attempting to commit assault in the second degree, and he caused her death in the course of that assault. The assault is the strangulation. Strangulation is assault in the second degree. And in the course of it, he caused her death. We know she died of strangulation. The second option is intentional murder, and that is that he acted with intent to kill her and that she died as a result. And then there's the requirement that it happened in the state of Washington, so that one's easy. The issue here, given how long it takes to strangle someone to death, is not intent. And given that strangulation is an assault in the second degree, that's not an issue either. The issue in this case is whether it was the defendant, right? What this instruction will tell you is that you don't have to be unanimous as a jury as to both of these. 6 of you may think option 1 applies, and 6 of you may think option 2 applies, and that equals a guilty. So that's what the confusing part is. You must be unanimous as a whole with regard to the crime, but the separate choices here, you don't have to be unanimous on those. So that's the 1A, B, C that you heard being read. The second instruction that I think is seriously important is the one that deals with circumstantial evidence. Circumstantial evidence is treated on TV sort of like a bad word. All you've got is circumstantial evidence. Well, it's just a circumstantial evidence case. It's like, well, guess what? Most cases have a lot of circumstantial evidence in them, because direct evidence is evidence from somebody who actually saw something happen. Eyewitness, video would be direct evidence. You could argue that DNA is direct evidence because it is confirmed that it's something perceived that this matches the defendant. Circumstantial evidence is everything else that, based on your common sense and experience, tells you that a fact has been proven. And I think the example that was used in jury selection was snowfall. When you go to bed and there's no snow on the ground, and you wake up in the morning and the snow is covering 2 feet of your yard and everywhere around you, circumstantially, it has been proven that it snowed, unless you believe the juror that thought it could be styrofoam. But that's what circumstantial evidence is. It is something that your senses and your common sense tell you, you know what, because of this information, I can tell that this happened. And so this case, to call it a circumstantial case, is partly correct, but it's just like every other case in a criminal setting. There's both circumstantial and there's direct. You heard from witnesses who've talked to the defendant. You've heard from witnesses who saw things. You've heard from scientists. All those things are direct evidence. The only thing that's really, truly circumstantial about this case is that, like 90% of most cases, nobody saw it happen. That's because it happened inside a private home. It's not on videotape. It's because nobody was filming the murder. And you're left basically with the other pieces to fit together and say, are they enough to make the whole? So here's the key point. Circumstantial evidence is not a dirty word. The instruction tells you that one is not necessarily more or less valuable than the other. Circumstantial evidence has to have that value, or we would never be able to prove any criminal case. So please, when you think of it, try to think of it in its legal terms. In this case, the circumstantial and the direct evidence tell you that it did indeed snow outside. There are pieces missing. You didn't see the flakes fall. You didn't feel the weather suddenly turn cold. You didn't see the blizzard. Those are some pieces missing. Those are some questions that will never be answered. What did the flakes look like when they fell to the ground? How long did it take? How heavy was the blizzard? That does not mean that it has not been proven that it snowed. And that's true, again, with most criminal cases, and it's true in this case. There are questions that will never be answered because they can't be answered because of the nature of this crime, because of where it was committed, because of who it was committed by, and who it was committed against. And there are some crimes that make it easier to get away with murder, and one of them is killing your wife in your house when there's nobody else around. But after 6, now 7 long years, there's no rule that justice delayed is justice denied. And the evidence in this case is enough for that to carry through. You know, the defendant had in Nicole sort of the perfect victim, the perfect type of wife for someone like him with a few feelings or empathy. A woman who was sort of a pleaser, sweet, conservative, sober, and frankly a little bit of a doormat for him. And you remember he told the police in his statement that they hadn't had sex in 4 months. But that either was or wasn't his fault, depending on where he's talking in the statement. And his words say so much to tell us a little bit about the inside of his head, which is sort of where the epicenter of all this is.
I don't have much of a libido. Yeah, it's kind of opposite roles of what the stereotype is. Yeah, I don't. Sometimes it would be like, sometimes it would be a long between something together. I was tired. I went to the doctor to get, I thought I was depressed or something, so I went to the doctor to get meds. I try to work out. I work in the gym, and you think that would make you work out, but you actually work out less. So I was trying to work out more. I was really watching my diet and stuff the last couple months, so it'll get better. It hasn't yet.
I don't have much of a libido. Really? After everything you've heard. Opposite roles of what the stereotypes is, we can only assume means that he thought Nicole was more interested in sex than him. Again, it depends where in the tape he's talking.
I mean, I used to have a lot more libido, and we used to do more stuff like that, like we rent movies and go to Lover's Package and get some stuff or something like that. She doesn't want to do that kind of stuff anymore. Which I don't think is necessarily my problem. I don't think it's why I don't want to have sex with her anymore. I don't necessarily not want to have sex with her anymore. It's just not.
Okay. Not his problem that she doesn't like sex. I thought he just said that she did, and he was the one that was tired all the time. The bottom line is they had not had sex for 4 months. He did not like her anymore. Let's face it. She was not for him. He's probably a little bit disgusted by her by the time he killed her. He was done. You know, she was the type of person you heard from witnesses who apologized constantly, who lacked confidence, didn't have really, I think Jordan Cox called it a strong, positive self. She was always asking if she was pretty, is she too fat, She wasn't happy about her body. She was insecure in her marriage. Was she a good person? She actually asked that of Barbara and Adrian. She's very accommodating of the defendant, never want him to be upset. She called the gym so much that it interrupted their operations at the front desk. She was suspicious about where he was, and every time there was a new receptionist, she would ask a friend, do I have anything to worry about? Well, we know she did, indeed. So either she had great instincts or she was just terribly insecure and needy. But where do you think those insecurities came from? Regardless of where they started, where do you think that they were massaged and improved? More to the point, who do you think exploited them the most? Maybe the husband who publicly humiliated her, who in front of other people would say, you need to do something with your hair, you need to change your clothing, have you worked out today, are you going to run later, are you really going to eat that? Maybe the husband who told Renee Stewart that Nicole wasn't really an alcoholic, it was just something that she claimed to get attention. Maybe the husband with a need to control, who had a wife who basically let it happen, who was in love with him for whatever reason. The husband who would call her repeatedly when she was meeting with her AA sponsee, and once showed up to cut the lunch short, let's go. The husband who she had to ask permission to do things. The husband who caused her visits with friends to be shortened because she was always worried about getting home to him. Maybe it was the husband who wanted her to be looser, more sexual, more outgoing, who found her boring, his words, and not fun, his words, because she didn't like to go to clubs and drink, because she, unfortunately for him, was sober, and she didn't like the smell of alcohol on him, and she didn't drink herself. And so he exploited that in the worst possible way. He not only slipped ecstasy into her drinks, he slipped ecstasy into the drinks of a woman who was in recovery, putting her sobriety at risk, putting her heart rate at risk, putting who knows what else at risk physically, to satisfy his desire for her to want to engage in a sexual threesome and to perform sexual acts on him in public. And it worked, didn't it? He wanted something other than her, and it was sort of a desperate act to try to make her into what he wanted. He wanted a fun girl. He didn't want a boring girl. He wanted a girl who would do threesomes, who would do these sexual things in a looser fashion. And you saw the woman on the stand, one who wasn't the sweet, sober, conservative, maybe a little dowdy Nicole. So why does this matter? It has to do with this case, with what this case is about and what it is not about, in equal measure. This case is not about the defendant being an evil person or a premeditated murderer. This was an act, probably spontaneous, an act of passion. There's no claim of premeditated murder here. And there's no claim that he's bad. He's not charged with those things. He's charged with killing her in the course of a strangulation or intentionally killing her. It's not about committing character assassination against him just to make him look bad to a jury. This case is about him being guilty of murder because not that he partied and cheated on his wife and hit on other women or wanted her to be something that she was not. This case is about how all that fits into the proof of the murder and the motive that he might have had when this argument happened and he put his hands around her neck. So I want to make that very clear. This is not about what a bad guy he was. This is about how his behavior affected what happened to Nicole. Again, an easy thing to forget when you get sort of the salacious stuff that was floating around this courtroom. Because there was a pattern that was evident here in this marriage. It started from the time he was engaged to her, when he told his lover or his woman who said they did whatever she described sex to be, that it was too late to back out of the engagement now, and who he kept seeing on his lunch breaks and in the evenings after he was married to Nicole. It's a pattern that shows he was unhappy in the marriage, that he wanted something else, and most seriously and importantly, that he did not care about her. And he probably didn't like her very much. That sets the stage for whatever argument took place the night of January 27th into the early morning of January 28th. And you'll notice in the to convict instruction that that's how this case is charged. It's a course of days. The law allows for that because sometimes we don't know the precise moment that something occurred. And so we charge a span of time. And we know he got off a little after 11 on the 27th. And we know approximately within a few hours when she died. It could have carried over into the 28th. That's why it's charged that way. Whatever argument took place, we are never going to know. And that's because of the nature of this crime. If it was required that we knew the words that were said, the actual trigger, what someone said to the other person to make them mad enough to put his hands around her neck and squeeze with his full body weight on top of her, pinning her down so she could not fight back or move, there would rarely be convictions. And then it sets the stage for the series of explanations to cover his tracks that he had to set up. As I said, it's all about what his motive might have been to assault her. The anger that had built up, the frustration, the disappointment, the dissatisfaction in his marriage that built up to an assault that ended up causing her to die. Or his motive to want her dead once he had the opportunity to break free, and whatever happened provided that opportunity, and he simply lost whatever control he'd been able to previously contain. Again, this is not a charge of premeditated murder. We saw the disregard for Nicole and their marriage vows. in his dealings with other women, and we won't go through them all again. You heard what they had to say. But there's certain things that came out from them that I think are significant in the scheme of all this. You remember Sabrina, the one who really cared for him and thought he cared for her, the long-term relationship, and what he told her about Nikki, and how he told her his wife doesn't like it when I drink. We get in arguments about it when I drink. And with Sabrina, he could bring over wine for her and beer for himself and escape and take his long lunches and tell Nikki he was playing Halo video game at Derek's house. And Samantha and Julie and Renee. The defense said in opening that this behavior was inappropriate and immature. That is certainly true. But it's a little bit more. It's a demonstration of the motive that led to whatever loss of control he had the night that she died. And that makes it relevant to this situation when he had the maturity to strangle someone to death. Now, the defendant himself, when he talked to the police, we have to listen to his own words. And I want to double check something. The tape I was going to play was one I just played you, so I won't do that again. The defense also told you in their opening statement, and no doubt will tell you in closing argument, that this was a long time ago, and that his behavior was a long time before Nicole died in 2006. Well, it was a long time ago from today. It was 7 years ago. But it wasn't a long time given the length of their marriage. And you'll see the marriage certificate, it's in evidence. They were married in April of 2002. And this activity that you heard evidence of was in 2001 and 2002 and 2003 and 2004 and up until 2006. When he hit on Andrea Seahort 5 to 6 weeks before he killed his wife. And it continued just 2 weeks after her body had been found, when he asked Troy Wakeman if he thought it was too soon to start dating. This is this pattern that's ongoing and helps us understand what happened the night of January 27th and the early morning hours of January 28th. And this is what happened and why we know he did it. She never left the house alive. She never left the house alive. He killed her in their home. He killed her in their home. We know, because of everything we've learned, that Nikki didn't split to go deal drugs. She had plans. 2 to 2.5 hours before the defendant got off work that night, she emailed Jordan Cox, her friend from work, about a training they were doing that following Tuesday and saying how excited she was for it and could not wait. She had a new puppy. She had a new condo. She had an AA sponsor that she cared about. She had an AA sponsee that she cared about and had a responsibility for and took that responsibility very serious. She had a job with responsibility. She had friends. And she had a husband who, for some reason, she loved. Okay. She told everyone, and she had even planned out that she was getting dressed up for that meeting and make her entrance and give her little talk. For a woman with the questionable self-esteem that it appears Nicole had, it may be that AA was her proudest accomplishment. She told everybody about it. She was not at all hidden about it. There was nothing anonymous about her. She was devoted to her sobriety, and that birthday meant something to her. The necklace that she wore, remember, Barbara, her sponsee, told you, that cross kept her grounded in her sobriety. Her doctor says she was devoted to her sobriety. She did not want narcotics from the moment she walked in that doctor's office. The doctor had to urge her to take the pills for the excruciating pain. And her friends said she was committed to her sobriety. She wouldn't go out, even when the defendant was out clubbing, without her. And she felt left out of the fun. She made the choice not to put herself in those situations. Until she did. And boy, she proved the universe right, didn't she? Let's remember that the defendant is the one, no one else who knew her, no one else who knew her, who planted the idea that she relapsed or that she'd taken off to go be with drug dealers. He planted that idea in that every time someone came to see him about her or talk to him about her, he would volunteer. She left an empty bottle of pills on the counter, and he would go get the bottle and he would show them to prove it. Barbara, Tanya, Rod, Gail, Ellen, the very night she was officially missing. He showed them all that bottle without prompting, on his own, to try to set this story up. Officer Binkley, the first to take the report, same thing. Officer Pinsky, the second to take a report, same thing. And his email that he sent out to friends on Sunday the 28th went into great detail about finding that empty bottle. Not just, have you seen Nicole? She hasn't been in contact. I'm really worried about her. It was a detailed rendition of finding the empty bottle of Percocet on the counter, 56 pills, not there anymore, setting it up. So the defendant had two explanations for what happened to her, basically, and two possible scenarios. He could hope that her body would not be found, ever, that it would decompose into those blackberry bushes. And people would assume that she relapsed. That would be a very simple explanation. His nonchalance, while other people were desperately searching for her, certainly suggests that he thought that's what was going to happen. It was an easy out and an awfully handy solution. He had a wife who used to abuse pain pills 8 years before. So he immediately took pains to point out that empty bottle, one from which he probably flushed the pills down the toilet, to start setting up that scenario. Or he said she must have fallen in with the wrong crowd, was the way he put it. That she was, as he told Rod, maybe out on 2nd Avenue selling drugs in Seattle. Well, now he's stuck with that because her body was found. And he knew she wasn't taking pills much anymore. And we know she wasn't taking pills at the time to any degree at all. And so a relapse is out. Her toxicology report tells us that. Those pills, those oxycodone, you remember Barbara from AA? She said Nikki never had control of that bottle. In AA, you give it to someone to dole out for you, just to be extra special and extra careful. You get someone to hang on to the pills, and when you need them, they give them to you. You remember Ellen, her friend that she was supposed to have dinner with that night, actually took her to get the first prescription and hung on to the bottle until the defendant could come pick it up. Because, as Dr. Waymack said, he was supposed to be the one doling out the pills to her. And the defendant told the police he did that until somehow the pills ended up in her purse and he just quit paying attention. That's what he said. You remember when police told the defendant that they found her body? And he appeared, according to Detective Anderson, to cry without crying. That he made the appearance of crying, but there were no tears. It wasn't because she'd been murdered. He already knew that. It was because her body had been found. And things just got a lot more complicated for him. And part of it was he needed to look like he was the devastated husband. And because that behavior fit with what he realized at that point, long after he hadn't taken any part in the search for her, long after he stopped bothering to call her, although she was missing, long after he figured he was probably in the clear and he just sort of stopped trying to do anything, now he realized with the finding of her body that he had to start acting the part. But he can't. He's not any good at it because he doesn't have it in him to care for her. So apparently, I guess, we're to believe that she took the pills to go sell them or hook up with a drug dealer. But it's a funny thing, one of those little things he didn't think of. Why would she take the pills but leave the pill bottle behind? She put them in a baggie? Put them in her purse loose? Wouldn't you want to take the pill bottle to prove that they are what you say they are if you're going to be selling them or doling them out as a drug dealer? No one thought she was close to relapse. And we know that she did not relapse. That was a plant by the defendant. And why was that? Because she had been killed at home by him. How else do we know she didn't leave the house? Her ring, her wedding ring that had major significance to her because it embodied her vows, which she took very seriously. And she left it behind. She left that ring that she cleaned and showed off and made sure was in every picture she took, and she left it behind. He forgot about that part. Oops. Remember, Barbara said Nikki loved that ring. She was always displaying it. Tanya said Nikki loved that ring. She was never without it. Ellen said Nikki loved that ring. She wore it always. And she even showed Ellen the cleaner that she used to make it sparkle. Remember, like the pill bottle, the defendant volunteered to people that came to the condo worried about Nicole that he and she had taken to not wearing their wedding rings sometime. He just sort of volunteered that out of the blue. And what do you know, her wedding rings had been left behind. That must be why, because we weren't really wearing them. Really? Then why was it so suspicious to him that she left it behind if she hadn't been wearing it? What was the big deal about that? That's a little thing he didn't think of. He's making excuses because he has these things that he didn't think of or he did not have time to think of. Remember, we're talking about a very narrow time frame that he had to work within to set this all up. And we know that she died at home because of when she died. Remember the tracking testimony about how you can age a leaf from how it's bent, and the decomposition of the vegetation around her. And Detective Decker testified she thought she'd been dead about a week, plus or minus. And I want to show you the calendars because I know you've had to look at these a lot, but they're not going to be in the jury room with you. So let's get a sense of the time frame. What we're talking about, right, is the night of January 27th into the morning of January 28th. He goes to work at 9 a.m. So that's the charging period. Her body is found February 6th. That's a week, plus or minus. Everybody's been consistent about that. The medical examiner, the trackers. Dr. Masrum told you that decomposition of a body, and I'm sorry you had to see those photographs. The lack of rigor mortis that has passed, the fixed lividity of the blood in the body once the body's positioned. And remember the waterlogged hands and feet. Sort of bathtub hands, right? The pruned up hand. That hand had been in water for a long time. You remember it was pouring rain that week, except for the 5th and the 6th. So we know she was there long before that, long enough to have this effect. on her hands and feet. It's also, that time period, completely consistent with the end of the activity on her cell phone in terms of her calling out. It stopped the night of the 27th. And it's consistent with the end of activity on her bank card, taco time, the night of the 27th. And it's consistent with her lack of contact with friends or coworkers, everyone who was calling and pleading with her, please get in touch, everyone except her loving husband. And the acetol, right? You know, it's interesting, as painful as Crohn's disease is, the ulcerations that it does on the inside of your gut, she didn't take the pills with her that would have made that feel better. What we have instead is inside her stomach 4 pills that are so intact they could read the writing on them. I've never seen a pill that actually has the name of the medication stamped on it. Take a look at it, it's pretty amazing. When you think about it being in her stomach and they were able to read it at the autopsy. Undigested. Because she took them before going to bed and she was killed before they could get to her intestine and dissolve where they're supposed to dissolve. If you assume otherwise, that she actually left the condo that next morning, you have to assume she took the loose oxycodone pills with her, leaving the bottle behind for some reason unknown. She didn't take the painkillers for her intestine. And she took the acetol that was in her stomach 3 hours before this phantom drug dealer killed her, right? Because that's how long it takes for them to dissolve and get into the, or to get into the intestine where they dissolve, depending on if you have food in your stomach. And the food. We don't know exactly what she ate that day. That's not part of your instructions, that has to be proven. It matters only in terms of helping us to time when she died. So, not to hyperanalyze, we do know this. All the discussion from Bill Schneck at the lab comes down to one thing. She had Mexican-style food in her stomach. Not pasta, not McDonald's, not teriyaki, Mexican. The last purchase on her debit card was at a Mexican restaurant. She had pinto beans in her stomach, and hot sauce, and peppers, and seeds, and starches. We know from Tanya that she didn't like tomatoes, so that solves that problem. And she had foods, Tanya said, that would wreak havoc with her Crohn's disease. So we don't know what she ate exactly. We know from Denise Lear at Taco Time that you could order a crisp taco with pinto beans if you asked for it. It was the only way that you could get that. And we know that lettuce may or may not have shown up in the stomach if she'd eaten it. We don't know if she ate it. We know that cheese turns into some sort of liquid that can't even be tested for by the lab. And Mexi fries, assuming she ate those, she who was watching her weight so carefully, could digest quickly or become a paste that would be indecipherable in the stomach as well. So we don't know exactly what she ate. The only reason any of this matters is because we have a receipt that says she made the purchase at 6:22 p.m. on the 27th. And there was Mexican food in her stomach. And it takes about 6 hours for the stomach to empty of a meal. 6 hours to digest, maximum. Maybe, I think one expert said possibly 7. And so if we assume she drove home from Taco Time and ate the meal, let's say within an hour of her arrival, let's even cut it back. Let's say she ate it by 7:30. Plenty of time for that food to remain in her stomach all the way up until 1:30 a.m., even if you keep that tight of a timeline. More than enough time for the defendant to get off work after 11, get home, engage in whatever happened, pin her down and strangle her to death, while those undigested alcohol pills sat in her stomach too. This might be a good time to break if we're going to take one.
Take a morning recess.
Your Honor, do you want to say anything on the record where you need to be?
I don't think so, unless you have something.
No, I don't, Your Honor.
No, I'm.
Thank you.